term violation is defined as 1. An infraction or breach of law, a transgression. 2. The act of breaking or dishonoring the law or the contravention of a right or duty. 3. Under the Model Penal Code, a public welfare offense. Quote, in this sense, a violation is not a crime. See Model Penal Code section 1.045. As highlighted in Black's Law Dictionary, a violation is not a crime. In contrast, the term crime is defined as a social harm that the law deems punishable, the breach of a legal duty that is the focus of a criminal proceeding, also known as a criminal wrong. The frequent mention of law in these definitions might seem confusing. So, which law are we talking about? In cases involving Alice or a living individual, the focus is on God's law or the law of the land, often referred to as common law. When Alice says, "I don't consent," she is simply removing herself from what some refer to as commerce, which Black's Law defines as conventional law. Conventional law includes policies that apply primarily to those who may not fully understand their right. Typically, with deeper understanding, one might align with God's law as a living soul which transcends even the Constitution. When Alice asserts that she is not driving a vehicle, despite appearances suggesting otherwise,
and traveling in my personal property.
Gotcha.
the specific language being used is crucial to understand. The term vehicle, as in motor vehicle, is defined as something used as an instrument or conveyance or any conveyance for transporting passengers or goods by land, water, or air. And shockingly, conveyance is defined as, quote, the voluntary transfer of a right or property. This implies that a vehicle is something created when you voluntarily transfer ownership of your property to the state. Most people unknowingly do this when they register their mode of transport as a vehicle. So when Alice claims she was traveling, not driving, this distinction becomes clearer with a few additional definitions.
And traveling in my personal property.
According to Black's Law Dictionary, 7th edition, a driver is 1. A person who steers and propels a vehicle, or 2. A person who herds animals or a drover. And importantly, driving is defined as the act of directing the course of something like an automobile or a herd of animals. Driving at home, the automobile exception is defined as an exemption from the requirement of a search warrant, allowing police to search a vehicle without a warrant if there is probable cause to believe it contains contraband or evidence of a crime. Therefore, you are only driving when you are in property you have voluntarily transferred to the state designated as a vehicle. Additionally, if you claim to be in an automobile, it is also defined as a vehicle. Conversely, a traveler is defined as a person who moves from place to place for any reason. Understanding these definitions clarifies why one might identify as traveling instead of driving should they choose not to consent to the conventional legal framework that governs vehicles. Understand that traveling is a fundamental right protected by the Constitution, particularly under the 1st, 4th, and 14th Amendments. The Supreme Court has consistently upheld the right to travel as a fundamental constitutional right, as seen in landmark cases like Marbury versus Madison and Shuttlesworth versus Birmingham. In contrast, driving is considered a privilege, governed by state regulation and subject to specific conditions and restrictions. Driving is viewed as a commercial activity under Title 18, Section 31 of the U.S. Code. In Alice's situation, she was not engaged in commercial activity, but was merely exercising her right to travel. She was not operating a motor vehicle as defined by Title 18, Section 31, but was using private property, which is not bound by the same regulations and restrictions as a motor vehicle.
And traveling in my personal property.
Gotcha.
Stepping outside of conventional law places you firmly in what is known as the private domain. In this context, you don't drive vehicles. Instead, you travel with your personal property. And property is defined as, quote, 1. The right to possess, use, and enjoy a determinate thing, either a tract of land or a chattel, and also the right of ownership. The institution of private property is protected from undue governmental interference. Or 2. Any external thing over which the rights of possession, use, and enjoyment are exercised. And for context, privacy law refers to a federal or state statute that safeguards an individual's right to be left alone or limits public access to personal information like tax returns and medical records, also known as the Privacy Act. Private is defined as, quote, relating or belonging to an individual as opposed to the public or the government, confidential or secret. By removing oneself from conventional law, one remains in the private domain. Your vehicle, belongings, home, and other possessions are classified as private, and as long as you don't infringe on others' rights, they are protected from government interference. When exercising your rights, you transition from conventional law into common law. A notable advantage of this transition is retaining the ability to use conventional law against government officials, like police officers or other individuals who may be unaware of their rights, placing them under conventional law jurisdiction. With this understanding, it's clear why hiring an attorney can contradict asserting your rights, leading to latches. Legal representatives typically advise pleading not guilty and waiting for a plea deal instead of immediately seeking a jury trial. Representing yourself pro se suggests a readiness to invoke your right to a speedy trial, thereby avoiding the implication of latches which arises if you demonstrate ignorance of your rights. Much like Neo in the Matrix, you must be wholly prepared to take the leap. If you're not ready to fully commit, it's wise to wait until you are.
Inadvertently gotten a sassy answer to that question from attorney Mark Koplik in its hidden camera video. Koplik explained to the representative of the phony African minister why he never worried about government subpoenas.
They don't send the lawyers to jail because we run the country.
You run the country.
Still do.
I love it.
Still do. I should say some lawyers run the country.
So you are some of them. Two of them.
Yeah, a small amount. We're still members of a privileged class in this country.
So what does it mean you run the country? Means you...
We make the laws, and when we do so, we make them in a way that is advantageous to the lawyers.
227 with no convictions. I don't know what her deal is.
Yeah, she's pulling like the sovereign citizen thing. Like, have I committed a crime? I'm a traveler on this roadway.
But
Yeah, so
okay.
she's doing all that. No, Sarge, I don't think she's DUI or anything. She's being very like sovereign citizen, like I'm traveling on the road. I don't need to identify myself and so forth.
Yeah.
I know. I'm gonna take her back and get to it.
Nah, she's just sovereign citizen, I'm assuming.
Oh, yeah.
I get the straw man stuff, I get all that stuff. I just need your ID.
You apparently are the strong man or the straw man?
Straw man?
Straw man.
No.
This is funny because we were just talking about sovereign citizens the other day and how we never really dealt with one, and now there you go. What's a straw man?
The straw man is what was created with the whole license piece.
Gotcha.
What exactly is a sovereign citizen? From the perspective of someone who has studied this topic extensively, the term appears to be a form of psychological manipulation. It is akin to removing civics classes which taught the Constitution from schools and replacing them with the generic social studies classes, which some say was more of an indoctrination rather than education. The term sovereign citizen itself is an oxymoron, meaning it's a contradiction. According to the well-respected Black's Law Dictionary 7th edition, being sovereign means one possesses independent and supreme authority or is the ruler of an independent state. In contrast, a citizen is defined as, quote, a person who by either birth or naturalization is a member of a political community owing allegiance to the community. Thus, one cannot be both sovereign and a citizen at the same time. The usage of sovereign citizen may serve as a technique to control Americans, who might have largely forgotten about their inherent rights and the power of the Constitution. In 2010, the United States government, through the FBI's Domestic Terrorism Operations Unit, released a document marked Law Enforcement Sensitive titled Sovereign Citizens, an Introduction for Law Enforcement. This document has since been made public and provides some shocking details surrounding sovereign citizens and law enforcement. It provides an overview of the behaviors and indicators of individuals identified as sovereign citizens, labeling them as a type of criminal, which serves as the basis of what law enforcement use to categorize such individuals based on their observed actions. The document states, quote, the purpose of this primer is to assist law enforcement in the identification of sovereign citizen extremist activity to prevent, detect, and/or deter acts associated with sovereign citizen criminal activity. Further stating, quote, in this report, sovereign citizen is used to reference individuals who declare their sovereignty from the United States by overtly filing fraudulent documents or committing other criminal activity. The document goes on to characterize certain actions, specifying, quote, "Sovereign citizens have committed the following violations: felonious attacks on police officers, filing liens and making threats against federal officers, bank, mail, wire, and mortgage fraud, conspiracy, creating fictitious obligations, using coinage that imitates official currency, passing or issuing silver or gold coins, money laundering, tax violations, and even illegal possession or sale of firearms." Additionally, the document states that, quote, "Sovereign citizens are known for traveling across the country, conducting seminars on debt elimination schemes, and routinely engaging in financial crimes, such as mortgage and credit card fraud. They may also create fraudulent businesses even while incarcerated to secure credit from legitimate banks." This document appears to aim at classifying those who assert certain rights and attempt to operate outside traditional legal structures as criminals. It notes, quote, "These groups generally do not adhere to federal, state, or local laws. Some sovereign citizens believe federal and state officials have no real authority and will only recognize the local sheriff's department as legitimate governmental authority." We should keep in mind a sheriff and a police officer both work in law enforcement but have different levels of authority. First, let's go over sheriffs. As an elected official, sheriffs oversee law enforcement across an entire county. Their duties include managing county jails, serving legal documents, and ensuring court security. Sheriffs have jurisdiction throughout the county, including areas not covered by municipal police forces. If police officers commit a crime, it falls under the sheriff's responsibility to investigate and potentially arrest them. Additionally, sheriffs even have the authority to deputize citizens he deems fit, empowering them to assist with law enforcement. While in contrast, police, hired by a city or town, police officers focus on enforcing laws within their municipal boundaries, handling tasks such as responding to emergencies and conducting criminal investigations within city limits. In terms of governmental authority, sheriffs can assert their power over federal directives, including presidential executive orders, if they believe those directives infringe upon county sovereignty or local laws. This positions sheriffs as a significant line of defense in preserving the rights and freedoms of Americans, especially in scenarios where government corruption might undermine legal and civil liberties. In 2022, Joe Davidson from the Washington Post cited the Pew Research Center, noting that 80% of Americans did not trust the United States government. By 2023, this figure had risen to 84%, according to Pew Research Center data. In contrast, back in 2010, when this document was released, only 19% of Americans reported trust in the U.S. government. The document seemed to label a significant portion of Americans, 82%, as potential criminals simply because they distrusted the government, stating, quote, "Sovereign citizens believe the United States government is illegitimate and has drifted away from the true intent of the Constitution. As a result, the United States government is not perceived to be acting in the interest of the American people." The document mentions that indicators of someone identified as a sovereign citizen included writing their name in all capital letters, notarizing documents, writing their name formatted with their last name in front of their first name, signing with SLS, meaning sovereign living soul, and even enclosing zip codes and brackets. There's a belief among some that individuals like former President Trump haven't disclosed their taxes because they haven't filed them, possibly viewing taxes as voluntary. This document appears to label Americans who question the legitimacy of taxes as criminals, stating, quote, "Individuals who adhere to this ideology believe their status as a sovereign citizen exempts them from U.S. laws and the U.S. tax system. They believe the U.S. Federal Reserve System, the Treasury Department, and banking systems are illegitimate. Therefore, one of the perceived benefits of being a sovereign citizen is not paying federal or state taxes." Interestingly, there's a more official take on taxes being voluntary from the government itself. In 2013, California Representative Xavier Becerra referred to the tax system as voluntary during a May 17th hearing with the U.S. House of Representatives. Becerra stated, quote, "We have to maintain confidence because it's a voluntary tax system." The acting commissioner of the IRS, Steve Miller, responded, quote, "Agreed," end quote. Becerra reiterated, "We need to clean up and clear out. so we can make sure people respect that we have a voluntary system of paying taxes, end quote. Although brief and somewhat vague, these exchanges suggest a government-level acknowledgement that aligns with claims about the nature of the tax system. Some see this as an example of government maintaining plausible deniability. It raises the idea that Becerra might be subtly hinting at a deeper truth. The context was a hearing on the IRS targeting conservative groups, adding a layer of complexity when compared to labels like sovereign citizens. This government terminology equates to criminalizing actions when citizens assert their rights. The U.S. government educates law enforcement to view legitimate rights assertions as potentially criminal. It suggests the government might be trying to suppress the rights of Americans, echoing a metaphorical Stockholm Syndrome type of legal restraint system for those who haven't had the chance or taken the time to see through it. Consider looking up the definition of treason in your Constitution, United States Code, and Black's Law Dictionary the next time you're doing research. Furthermore, it's perplexing when government rhetoric on the legitimacy of certain mechanisms contradicts occasional admissions by officials. Hearing these statements directly from officials can provide important context and clarity. Here's a short clip of their 2-minute interaction during the IRS hearing on targeting Americans, noting Becerra's difficulty with his words and the IRS commissioner's readiness to agree.
I think the president actually said it better. He said that the handling of those tax-exempt applications in that process at the IRS was outrageous and intolerable. No excuse. And as much as we know that the folks at IRS have a thankless job because they have to go and tell their fellow Americans that they may be audited or they have to do this work understaffed, we have to maintain the confidence in the system because it's a voluntary system of payment of our taxes.
Agreed.
Because it's a voluntary system of payment of our taxes.
Agreed.
And so you are right. It was a foolish mistake. But the president's even more correct that it was outrageous and intolerable. Now, let me also focus on something, Mr. George, you said. When you were asked, was there any finding or evidence of political motivation here, you said no.
That's correct, sir.
Okay. And so what we find is a situation where inexcusable activity took place because it erodes the confidence of the American people in a system where they participate voluntarily. And if there's a place in public service where you have to have the highest level of conduct and standards, it's at the IRS. And so, Mr. Miller, I think it's unfortunate for those who are in positions of authority, but the buck has to stop somewhere, and I think that's exactly what we're saying. That should not diminish the good work that has been done by anyone within the IRS over the years. And so I hope you understand that you are here today talking to us because we need to get to the bottom of this. We need to clean up and clear out so we can go back to the business of making sure that people respect the fact that we have a voluntary system of paying our taxes. Making sure that people respect the fact that we have a voluntary system of paying our taxes.
It's crucial, if ever reaching jury trial for anything related to sovereign citizens, like in Alice's case, to make sure you, 1, reject all jury participants without sufficient intellect and vet them by doing things like asking them vocabulary questions. And 2, educate the jury to the best of your ability because all of this knowledge is literally the opposite of common sense. While this may sound far-fetched, there are accounts from former IRS agents who resigned after discovering what they believe to be the truth about the tax system.
There is no law that requires the average American worker in the private sector to pay a direct unapportioned tax on their labor and compensation for services. There is no law.
I really expected that, of course there's a law that you can point to in the law book, the code, that requires you to file a tax return. Of course there is. Maybe I don't know what it is right then as he was speaking to me, but sure. So naively, I agreed to go off and research it and get back to him. 3.5 months later, I was at that point where I couldn't find the statute that clearly made a person liable, at least not me and most people I know, and I had no choice in my mind except to resign.
But We the People Foundation for Constitutional Education put a full-page ad in the USA Today on July 7th, 2000. And within the body of that ad was a $50,000 challenge for anyone that could show the law. And to me, $50,000 is a lot of money. So I went after that and did the research based on the fact that I thought, let's put this baby to bed. I'm hearing all these rumors. I'm going to kill two birds with one stone. I'll answer these people's questions that are asking me, and then I'll win this $50,000. And, based on the research that I did throughout the year 2000 and that I'm still doing, I have not found that law. I've asked Congress. We've asked a lot of people in the IRS commissioners, helpers. They can't answer, because if they answer, the American people are going to know that this whole thing is a fraud.
In 2008, former IRS agent Sherry Peel Jackson had the U.S. Court of Appeals for the 11th Circuit uphold the district court's decision to impose a 4-year prison sentence for failing to file income tax returns, as the evidence clearly demonstrated her willful non-compliance. A key component in tax defiance cases is the element of willfulness. To establish willfulness, the government must prove that the defendant acted with an intentional disregard for the legal duty to file tax returns. In Jackson's case, despite her claims of misunderstanding certain tax terms, the court found substantial evidence showing that she knowingly and intentionally failed to file her tax returns while maintaining a tax preparation business. Her own statements and the significant income she received reinforced this finding, indicating a conscious choice to violate the law within conventional law jurisdiction. She did not adequately explain the complexities of these issues to the jury. Just because someone is an IRS or other government official doesn't mean they are a legal expert. Gaining expertise in law requires significant time and dedication, time that she likely didn't have due to her busy schedule. Therefore, always ensure you have sufficient knowledge before trying to change jurisdictions.
There is no law, and to date, nobody has been able to show that there is a law for the average American citizen working day in and day out to pay an income tax.
In 2008, former IRS agent Thomas Selgas was sentenced to 18 months in prison, served 3 years of supervised release following his imprisonment, and to pay approximately $1,323,776.92 in restitution to the United States. He was charged with conspiracy to defraud the United States and for tax evasion. When reviewing the case, it's clear to see that by engaging an attorney, former IRS agent Tom Selgas placed himself within the realm of conventional law jurisdiction. Legal representation inherently involves acceptance of judicial processes and acknowledgement of statute-based obligations. This belies any argument that Selgas might have been outside such legal frameworks or operating under common law principles independent of statutory tax obligations. His deliberate interactions with the attorney aimed at concealing income revealed an active participation in conventional legal avenues, albeit for illicit purposes. Selgas also failed to sufficiently educate the jury. The jury was presented with tangible proof of conspiracy to defraud via the jurisdiction of conventional law, notably the use of an attorney's escrow account to conceal substantial income from the IRS. This evidence suggested intentional malpractice rather than innocence or error. To present a sufficient case, Selgas would have needed a narrative that either justified the use of such concealed transactions or disproved the notion of willful tax evasion, neither of which appeared convincing. What a party has acquired in terms of evidence means everything. It's always best to proceed like you're in a courtroom battle, using your notepad and pen as if it could draw you an entirely new world. Selgas's procedural and defense choices reinforced his placement within conventional legal jurisdiction and underlined his culpability in the jury's view. His strategic errors and legal maneuvers not only failed to shield him from prosecution, but also clarified his intention to evade tax duties deliberately. However, I am sure some people might use cases involving these agents as a way to discourage others from exploring legal matters. In his full interview, Joe Bannister discusses how the U.S. government tried to take legal action against him. He not only defended himself, but also claims to have won a lawsuit related to the alleged violation of his liberties. Referring back to the FBI document on sovereign citizens, everything appears to fit together in a notably uncanny way. His case is an important contrast and fitting conclusion to the tax aspect of illuminating the true intention behind laws or police policies enforcing sovereign citizen protocol. So let's take a brief listen to a 4-minute excerpt from his interview featuring former IRS agent Joe Bannister, who shares the compelling evidence they found in the IRS's own law library.
And what led you on this investigation to figure out whether or not paying income taxes was legitimate, was legal, was constitutional? And how did you have this come to Jesus moment about federal taxes?
My entire professional life revolved around the income tax. Earned a degree in accounting from San Jose State University back in the 80s, and earned my CPA certificate from the state of California. And so I was hired in San Francisco, sworn in November of 1993. But as I say, my entire professional life revolved around the income tax. I expected to spend a full 20-year career, law enforcement career with the IRS. I was having the time of my life living and working in the city that I grew up in, San Jose, and being a federal agent, a federal criminal investigator. So, if I had any bias at all against the information that I came upon, it was that, this stuff couldn't possibly be true. And so I was listening to this talk show hosted by a guy that was very trustworthy. He wasn't a partisan kind of guy. It was just about what's right or wrong. And he had a guest on his show, and she started talking about the income tax and saying that it was voluntary, that there wasn't a law, passed by Congress and signed by the president that made most Americans required to pay the federal income tax. And if you can imagine me driving around in my government car with my handcuffs and Sig Sauer 9mm and, saying, lady, this tax ain't voluntary.
Right.
But because of this talk show host and how truthful all of the previous guests had been, and how truthful he was like a colonel in the special forces of the Army, just a real trustworthy guy. So I thought, well, something's wrong here. And so I just started to deploy my training on my own time to investigate these claims to see what's this all about. At the time, they were called illegal tax protesters. So the IRS really had a bad thing for them. And so I just began to gather facts and to cut, give you the cash value. After 2.5 years, it was all through 1997 and 1998, going to the law library and really digging deep into these claims and using, every skill that I could muster, being a CPA. The IRS trained me in Glencoe, Georgia, at the Federal Law Enforcement Training Center. Upstairs in this, we called it the Gold Building, believe it or not, where the IRS was housed. Because in San Jose, California, on Market Street, it's literally got gold windows. Upstairs was the IRS law library. And so one of the claims was that the IRS's own internal manuals, called the Internal Revenue Manual, or IRM as the acronym, inside that manual, it would actually say that the IRS Criminal Investigation Division that I worked in, or the Examination Division, which is where the auditors are, or the Collection Division, where the guys that steal or take money out of your bank account and put liens on your houses and those things. If you look at the Internal Revenue Manual, you'll see that it actually lays out that the jurisdiction, the reach, the ability of these IRS agents is limited to Americans who are living and working abroad, outside the country, not inside the country where you'd expect, because that's where we see them. They're on TV, they're out there doing their audits and investigations. And I thought, well, that couldn't possibly be true. So I went upstairs to the law library and flipped through the official Internal Revenue Manual that the IRS, keeps for their own lawyers and accountants. And there it was. In fact, I've got that on my website on the landing page, agentfortruth.com. These copies of the Internal Revenue Manual that I looked at and thought, wow, well, this isn't a lie. This is exactly as these people that the IRS called illegal tax protesters are saying, that the IRS's own admission in their own Bible, their own manual, says that their reach, their jurisdiction is limited to Americans living and working abroad.
This document marked Law Enforcement Sensitive, titled Sovereign Citizens, an Introduction for Law Enforcement. Seems to portray Americans who are aware of government debt and question the intrinsic value of U.S. currency as criminals by stating, quote, Sovereign citizens believe the U.S. declared bankruptcy when the United States government was removed from the gold standard. As a result, U.S. currency, referred to as Federal Reserve notes, is perceived as valueless credit notes. The monetary system is now believed to be based on exchanging one credit document for another. Sovereign citizens believe this makes U.S. currency essentially worthless. It appears to target Americans who feel their rights have been violated by labeling them as criminals if they seek civil remedies, stating, quote, "Sovereign citizens may file lawsuits against law enforcement or members of the court in their individual capacity, seeking civil remedies for alleged violations of their constitutional rights." Additionally, it seems to discourage incarcerated Americans from using legal resources by implying they might engage in criminal activities, stating, quote, "While incarcerated, sovereign citizens may utilize the prison library to research federal and case law to determine new ways to create fraudulent financial documents and engage in criminal activity. Sovereign citizens may also train fellow inmates to conduct fraudulent schemes to defraud banks, credit institutions, and the United States government. The document indicates that sovereign citizens often file an affidavit of truth, declaring themselves as sovereign or freeborn sovereign under natural common law. The documents go on to say, quote, "They may attempt to void various legal and financial ties, including Federal Reserve notes, U.S. currency, bank accounts, social security number, driver's license, vehicle license plates, birth certificate, marriage license, U.S. citizenship, voter registration, past tax returns, and lastly, enrolling children in public schools. These actions are suggested to revoke implied consent to governmental authority at birth. The document appears to caution against mechanisms challenging government authority, such as the corporation sole, which it claims sovereign citizens exploit to avoid taxes and hide assets. It notes, quote, "A corporation sole is a legitimate statute for religious leaders to incorporate an organization to manage property. Sovereign citizens misuse it to avoid taxes, launder money, and conceal assets." The document bundles legitimate rights with alleged criminal activities, potentially confusing and deterring average citizens from asserting their rights. The document even admits, quote, "However, it is important to note these activities may also be indicative of lawful, innocent conduct and in some instances may constitute the exercise of rights guaranteed by the United States Constitution." In 2015, the FBI released a document marked "For Official Use Only" titled "Sovereign Citizen Extremism, a Primer," which has since been declassified. The document expands on the terminology used by law enforcement to describe individuals identified as sovereign citizens, stating, quote, "The term sovereign citizen is used mainly by law enforcement. Adherents tend to self-identify as sovereign, free men, flesh and blood persons, diplomats, indigenous Americans, living beings, etc. The government often includes disclaimers to protect itself from potential legal challenges related to these documents. These disclaimers, when combined with critical thinking, can also help readers dissect the document's psychological impact. The document even notes that sovereign beliefs are not inherently illegal, stating, quote, "Sovereign citizens make up a diverse, nationwide movement as opposed to comprising a single organized, homogeneous group. Because it is not illegal to advocate sovereign beliefs, the FBI does not maintain a count of sovereign citizens. The movement, which has its origins in the United States, has appeared in Canada, the UK, Ireland, Australia, New Zealand, and mainland Europe. This is seen as an example of doublespeak because sovereign beliefs could refer to either 1. the beliefs held by a sovereign citizen, or 2. American beliefs characterized as sovereign. Some might view this as the government's effort to obscure distinctions. Additionally, it states, quote, "It is not illegal to advocate sovereign citizen beliefs. Individual indicators of sovereign citizen activity may comprise lawful conduct or non-sovereign citizen criminal activity. No single indicator should be the sole basis for a determination of sovereign citizen activity." The document attaches a negative stigma to legitimate assertions of rights, potentially demonizing those who assert these rights to others who may not understand conventional law. This divide perpetuates an invisible barrier that inhibits people's awareness of their rights. By using doublespeak and multi-layered definitions, it discourages individuals from exploring their rights further. The document goes as deep as to specifically reference Moorish sovereign citizens, acknowledging, quote, Moorish sovereign citizens claim special status as non-citizen protectees of the U.S. government due to a treaty of friendship between the United States and Morocco, 1787-1836, or through alleged membership in Indian tribes. Not all self-identified Moors are sovereign citizens, and not all Moorish sovereigns are engaged in illegal activity. Furthermore, it appears to label individuals who possess significant knowledge of legal systems and the Uniform Commercial Code, UCC, as potential criminals, stating, quote, "Sovereign citizens claim to possess secret truths about the U.S. financial system, hidden conspiracies, or knowledge about supposed government-suppressed technologies." The term sovereign citizen is used mainly by law enforcement. Adherents tend to self-identify as sovereign, free men, flesh and blood persons, diplomats, indigenous Americans, living beings, etc. They purport special understanding about legal procedure, common law, and the Uniform Commercial Code, UCC. We discussed earlier the legal definitions of public and private, if you recall. The government uses language